Noise-induced hearing loss is one of the most serious and yet underreported examples of workplace injury throughout Ireland. The once thriving shipbuilding, aviation and textiles industries, for example, have left a lasting legacy on former employees who now suffer from hearing problems such as tinnitus and partial deafness. The issue with noise-induced hearing loss is that symptoms generally don't arise for a long time after exposure. This can lead to people failing to make further investigations because they believe it's a consequence of ageing. However, a substantial amount of noise-induced hearing loss cases can be linked to overexposure to noise in the workplace. For a viable claim for compensation, you need to establish three things. Firstly, that your employer or former employer owed you a duty of care. Secondly, that duty of care was breached. And thirdly, that breach of duty has caused your noise-induced hearing loss. Clients will often ask us whether or not they can make a claim for compensation a long time after the exposure, say for example 20 years. The simple answer is yes. Unlike in other personal injury cases where a claim for compensation must be brought within 3 years of the date of accident, in noise-induced hearing loss cases, a claim can be brought within 3 years of a link being established between the hearing problems and the employment.